People have the right to be free from getting headbutted and assaulted. I don't care what the relationship is. Maybe it's love, maybe it's a connection that they had, or maybe it's not thinking, being drunk and thinking they know better. In other words, we call that power. You don't get it. I'm going to do my best to make sure you get it. Stop beating up on women. So, Ms. Millette, we're here today for a hearing. What are we doing today?
Thank you, Your Honor. It's my understanding that my client is prepared to plead no contest to the probation violations.
Is he currently pending charges here or elsewhere?
Grand Traverse County.
Grand Traverse County, is that right?
That's correct.
Are those charges still pending or have they been resolved?
I believe they're still pending.
Okay, thanks. All right, Ms. Carey, is that what you thought we were going to do?
I wasn't quite sure.
All right, will you go ahead and figure out, and then if you got an exhibit, let's go ahead and get that marked. I'm going to turn to Mr. Reed. Mr. Reed.
Yes, Your Honor.
You are currently charged on a request and warrant for probation violations with 3 counts. Now, these are not new criminal charges, even though they may be based upon criminal charges from another county. And from what I'm told, you are facing criminal charges in Grand Traverse County for alleged acts that are consistent with these 3 probation violations. Are you on probation or parole anywhere else?
No.
So you just have this file and the one currently up in Grand Traverse, is that right? Okay. On this request and warrant, there are 3 counts. Count 1 alleges that you violated condition 4.18 of your terms and conditions, which requires that you are not to engage in any assaultive, abusive behavior. And allegedly, on May 14th of this year, you engaged in assaultive, abusive, threatening behavior toward a person named Carmen Young. Now I'm going to skip count 2 and say that count 2 deals with the same allegation, but a different count. That alleges a violation of Rule 1, which requires that you are not to violate any criminal law of any unit of government. And allegedly, again on that same date, May 14th, you assaulted or battered Carmen Young, or Carmen, sorry. Now, count 2 alleges you violated condition 4.15 that requires you are not to have any verbal, written, electronic, or physical contact with Carmen Young, and that you had contact with her on May 14th. Now, I'm told you're going to plead no contest to these 3 allegations. Now, no contest is the same impact as a guilty plea. The difference is, in a guilty plea, I have to have you tell me what you did that makes you guilty of allegations. However, in a no contest plea, the court can accept a no contest plea when there are certain reasons, such as the interest of justice, such as the fact that you're charged with another case in another county, and it has nothing to do with me. So, if I were to make you tell me what happened, that could be used against you, get you convicted in the other county. So therefore, I'm allowed to take a no contest plea. No contest plea means no contest. Now, the prosecutor is going to give me an exhibit, which I'm holding up. I haven't read it yet, but this is what they've given me. And when you enter a plea of no contest, everything in here I get to accept as true for the purposes of this file. Not for the one in Grand Traverse. This has nothing to do with Grand Traverse, but nothing, you can't come back and say, well, I disagree with that. You understand?
Yes, sir.
All right, those 2 words are very, very simple, but lots of people get them confused. No contest means I don't contest it. Okay? Now, I can take a no contest plea in certain circumstances, we've covered that, but if you enter the no contest plea, you're not going to have a contested hearing. Do you understand that?
Yes.
You're going to be given up the right to have the prosecutor prove the allegation by a preponderance of the evidence, the right to question and cross-examine any witnesses, review the evidence against you, present witnesses' evidence for testimony if you chose, and then the right to remain silent, of course, and the right to not have that silence used against you. Do you understand?
Yes, sir.
And if you're found to be in violation of your probation, you're going to be resentenced on your original offense. And in this case, you were originally convicted of attempted possession of a dangerous weapon, such as brass knuckles, and that is a felony, originally punishable by up to 5 years and or $2,500. And an attempt, generally people think it reduces the maximum punishment down in half, but what it really does is it reduces the guideline range to a different grid. The potential punishment is up to a year in jail or up to 5 years, but the guideline range is more favorable. Do you understand?
Yes, sir.
Okay, thank you. All right. Now, has anyone made any promises to you, or promises, threats, or injunctions? So, promises, threats, inducements to get you to plead guilty that we haven't talked about today?
No, Your Honor.
Are you entering this plea of your own free choice?
Yes, Your Honor.
And has anyone made any promise to you as to exactly what I would do if sentencing?
No.
Knowing all that, do you still wish to enter these pleas of no contest?
Yes, Your
All
Honor.
right, so I'm going to ask you how you plead to counts 1, 2, and 3. I'm not telling you what to say other than I'm suspecting you to say the words no contest. You'd be surprised how often after I say the words no contest that the person says guilty instead of the words no contest. But I'm told that you're going to say no contest. As to counts 1, 2, and 3, how do you plead?
No contest.
All right, before I can accept that plea, the court first takes judicial notice of the terms and conditions of probation that are contained here within the court file. They were signed by me on December 6th of 2024 and subsequently acknowledged by the defendant himself on December 13th of 2024. The court has now People's Exhibit number 1. Ms. Carey, are you offering that to support the no contest plea?
I am.
Ms. Mollett, any objection to the admission of that exhibit?
No, Your Honor.
People's Exhibit number 1 is hereby admitted. This is a Grand Traverse County Sheriff report printed on May 18th of this year, and it bears a incident report number of 26-8762. All right, Ms. Carey, do you believe this report, in addition to the judicial notice of the probationary term, satisfy the required elements of proof?
I do.
Are you aware of any other promises, threats, inducements?
I'm not.
And do you believe the court to comply with the court rules?
Yes, sir.
Ms. Mollett, do you agree with all those statements?
I do, Your Honor.
The court finds that the interests of justice do not require the defendant to recite a factual basis. Therefore, the taking and acceptance of a no contest plea is appropriate. The court further finds the information contained in this report, Exhibit number 1, in addition to the terms and conditions, satisfy the required elements of proof. The court also finds the defendant's plea today has been made freely, knowingly, and voluntarily. Therefore, the defendant is found guilty of counts 1, 2, and 3 on the request and warrant for probation violation that was filed in this record on May 19th of this year. Mr. Van Atwell, are we able to proceed to sentencing, or do the parties wish to delay sentencing?
I'm here.
All right,
That's fine.
Ms. Mollett, are we able to proceed to sentencing, or do you wish to have a delay?
We're prepared.
Thank you. All right, Mr. Van Atwell.
DeAndre was originally sentenced to a term of height of probation, 11/25/24. He received probation violations for assault behavior towards the same victim. Alcohol. Ida was revoked and he was sentenced to regular term of probation on 12/5/24. Sentencing guidelines are 0 to 6. He owes $1,560. Times the costs. He's made a total of $57. Jail credit, 31 days. That does not include the time. I would recommend 180 days jail, credit for 131 serves, probation terminated.
All right, thank you. You said the guidelines were 0 to 6, am I correct? All right, thank you. Ms. Carey?
Thank you. I'd ask the court follow the recommendation.
Thank you very much. Ms. Mollett?
Thank you, Your Honor. We would just be requesting time served.
All right, thank you very much. All right, Mr. Reed, when someone enters a no contest plea, it's not common for them to make a statement at sentencing. Obviously, because you entered the no contest plea, because you don't want your statements to be used against you. So if you make statements about sentencing, or at least making comments about what happened, those can be used against you. So, but I'm also still required to allow you the right to make allocution. Is there anything you wish to say without talking probably about what happened?
Yeah, whatever your sentence is it gonna affect the fact that I have to be up there on Thursday for court there?
No, it shouldn't. I mean, the answer is it depends upon the other court. The court can issue a writ, have you brought up there. That means they'd have to come down here and get you. So the point here is it may not, it will be out of my control. It will be in the control of that judge in the other court. Anything else? All right. Well, we've got repetitive behavior here that is really quite concerning. They involve acts of domestic violence. And that gives this court a great deal of concern. in this particular instance. Apparently here, at least while he hasn't been found guilty of consuming alcohol, there were statements here that Mr. Young, quote, got into Young's vehicle intoxicated and started to rev the motor. Then when Miss Young tried to get him out of the vehicle, he got out and headbutted Miss Young. So I don't know what it is that is not sinking in to the defendant's head. This court ordered him to have contact. Was there no contact? No, yeah, because after the probation violation. I understand it. People have the right to be free from getting headbutted and assaulted. And I don't care what the relationship is, and this often goes on in the mind of people who don't follow the rules. I don't think it matters. They can do whatever they want. Maybe it's love, maybe it's a connection that they had, or maybe it's not thinking, being drunk, and thinking they know better. In other words, we call that power. Well, domestic violence is something we need to get. Yes, sir?
It doesn't really make any difference, but I never received any paper, which I was still under the understanding, since I didn't receive any, that the no contact was removed. We discussed it last time I was at court. No one never said anything back to me.
The probation order he signed, 12/13/24, has a special condition added.
Yeah. Yeah, so I don't understand how you can think that, because it says it right on the piece of paper that you received and acknowledge receiving. But here's what I'm going to say. Even if it was, because I don't think you were found for violating the no contact, was there?
That was one of the violations.
Was it? Yeah. Regardless, you committed an act of domestic violence again upon the same woman. I don't care. I can't imagine what makes you think it's okay to have a contact with a person I told you don't contact. And then if you do contact them, their car, and then when they try to get you out, headbutt the person. So no, stop beating up on women. Pretty simple. And he didn't get you for the alcohol, probably because they didn't test you at the time and you weren't there. And they got you for that, you'd have another violation. So the answer here is you don't get it. I'm going to do my best to make sure you get it. I already revoked your HYTA. That didn't work. Back to assaulting the same person. So the court revokes probation, unsuccessful without improvement, which is consistent with the law allowed underneath MCL 771.4, based upon the fact that this involves no criminal behavior and it was domestic violence, yet again. And I know the guidelines is 0 to 6 months, but I find there to be substantial reasons to go above the guidelines because they're inadequate, because you can't seem to figure out to follow the rules. And I can't imagine what makes you think it's okay to approach her and headbutt her while drunk. So, no, 180 days is not going to be enough. Court sentences the defendant to 300 days in jail with 131 days of credit. And he finds that cross or preserved probation is terminated unsuccessfully. Beating up on people, especially significant other. Miss Carrie, there's your exhibit, and Samantha's going to bring you 2 copies of one document. This is called your rights to appeal, and I don't see them in there. If you can find them, great. If not, I'm going to bring out you 2 copies of one document. You're going to place your initials on one. Doing so neither elects nor waives your rights. It merely acknowledges your receipt of the copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case, and that's typically done by filing a claim of right to appeal. However, based upon the original plea in this case and the appeals and the pleas on the sentencing, or on the probation violations, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy of the document that you're going to leave with and return to the court within 42 days. If you choose not to appeal, you may simply disclose it or copy that document. Thank you very much. Anything else, Mr. Van Etmel? Ms. Carey?
No.
And Ms. Smollett?
No, Your Honor.
You haven't been dismissed yet.
All right, it's okay, everybody. Don't feel challenged. He's just doing his job. He wasn't trying to be rude. He's just telling you to sit down and take a break because he's right. I didn't tell you you could leave, but we're adjourned. Now you may go. Thank you.
Thank you, Your Honor.